All right, we will call up the final case, which is Randy Lee Jenks versus Bynum Transport. And counsel for the appellant, you proceed when you're ready.
Thank you, Your Honor. May it please the court, my name is Bill McCabe. I represent the claimant Randy Jenks. We submit the judge of compensation claims erred in concluding the claimant, who was injured during orientation, was not an employee at the time of the accident, and as such the judge erred in concluding the claim was not compensable. Now, we submit that the claimant at the time of his orientation, time of the accident, fits within the definition of employee, which is defined in Florida Statute 440-02-15A as any person who receives remuneration from an employer for the performance of any work or service while engaged in any employment under any appointment or contract for hire or apprenticeship, express or implied, oral or written. Now, this claimant was paid for the 2 days of orientation.
So he got paid for his 8 or 9 day trip.
Yes.
And when he got that check, it included the 2 days of payment for the 2 days of orientation.
Correct, and it's referred to as additional wages on his page 45 of the record, and it also says SAL orientation pay, which the SAL certainly one would think means salary. And he was also put up in a motel for 2 nights and 2 lunches and so forth. Now, I guess the next question is was he paid for the performance of any work or service while engaged in the employment under an express or implied contract? We submit that the contract was at least implied when he went to orientation, and I submit that...
Not everybody at orientation became an employee.
I beg your pardon?
Not everybody who went through orientation became an employee.
Correct. Yes, did not continue on as an employee, that's correct. But I submit that going through orientation is performing a service for the employer. I mean, it's also benefiting the claimant, there's no question about it. But it's also benefiting the employer because during the orientation, first of all, this claimant left a job of 6.5 years, traveled 2.5 hours to go to orientation at the request of the employer. While he underwent orientation at the request of the employer, while he was undergoing orientation, he was under the complete control of the employer. While undergoing orientation, he was learning the methods of the employer's business.
But he knew he had to meet some other hiring requirements before he actually got the job.
Well,
he had to pass a driving test, he had to pass a drug test, he had to pass a physical. So he knew there were other things that other requirements that he had to meet before he got hired.
Right, which were actually mere formalities. I mean, he already had a DOT license and so on and so forth. And another thing about
but the physical wasn't really a formality, neither was a drug test.
Well, in his mind, the claimant's mind it was, because he didn't do drugs and, he's passed physicals before. But also as a key, as soon as the orientation was over, he was sent out on the road. And they apparently knew he was going to be sent out on the road even before orientation was over, because that's what caused his wife to come there on the 2nd day of the orientation so he could get stuff out of the car so he'd have the tools and the things he needed when he went on his trip.
Do you think that he met the definition of an employee for the brief period during the orientation, regardless of whether he would have been offered a permanent job or not?
Well, actually, I think so, because once he went to orientation, the risks of employment were there. Now, I couldn't find a Florida case on this, whether somebody was injured during orientation or not, so I had to go out of state. And I found a Tennessee case that seems pretty close to on point. It's the Hubble versus Dyer Nursing Home case, and it's cited in the brief, but in that case, the girl was going to work for a nursing home, but she had to undergo 3 days of orientation before she actually started her job.
But she'd actually been hired, but couldn't set foot inside the facility until she'd gone through some additional orientation.
Well,
which is a little bit different here.
The employer in that case testified that she actually wasn't hired until she completed her orientation. That's what the employer in that case testified to. And the Tennessee court noted, number one, that she was paid for the orientation, and that number two, her job started immediately after she completed orientation. Well, that's exactly the same thing we got here. The claimant was paid for orientation and started his actual job as a truck driver immediately after orientation. My alternative argument on that is if you feel maybe, well, he might not have been an employee until he completed all of these tests and so on and so forth, is that he was then hired as an employee retroactive to June 22nd after he completed the orientation because they paid him wages. And I would submit, why would anybody pay somebody wages if they're not an employee? So
You don't think they did it out of the goodness of their heart? You think they did it to pay an employee?
they call it wages. They tried to testify that, well, I didn't try to testify. They did testify it was like seed money for his trip, although he didn't get it until after his trip.
But I mean, because in all seriousness, their argument is all the motel, the lunch and all that, those are expenses. They're allowed to provide, in fact, it's a per diem. Their argument is that $50 a day was strictly a per diem.
Well, I think they wanted to make their documents make it look like he wasn't an employee during orientation. I mean, it's, for example, when he signed the sheet about, if you have more than 3 tickets in the last year and things like this, they may be grounds for disqualification and termination of employment. But they signed that on June 22nd, but they dated it where it says hire date on June 23rd. Because, I mean, they're just trying to make things look like he wasn't an employee. But on their settlement sheet, which is on page 45 of the record, it says the $100 is additional wages, orientation pay. So, to answer your question, I mean, if they wanted it to just be a gratuity or whatever, I don't know, maybe they need to change the verbiage in what they use in their own forms. But again, I would submit you're not going to pay somebody wages if they're not an employee. And so we feel that the judge erred in, and the standard of review, I think, is de novo, because the facts are really unrefuted in this particular case. And I think the court can determine whether this injured worker was an employee as a matter of law. Thank you.
May it please the court. My name is Bill Rogner. I represent the employer carrier in this case. Judge Clark, you questioned whether everyone became an employee, and of course they did not.
Of course.
Some made it and some didn't. Some quit, some were sent home, and those that didn't make it didn't get an offer and didn't get the $50. Only those that completed the 2-day process at 5 p.m. in the afternoon at the end of the second day were given job offers and got that $50 in their first paycheck.
But is the question whether he was an employee in the eyes of Bynum Transport, or whether he was an employee under the meaning of the Florida Workers' Compensation Law?
Well, the latter.
You can say if you want to, well, I've got to have a written contract. Well, but unfortunately, if you want to say that, that's not going to hold up, because the Workers' Comp Law doesn't require that.
No, but let's look at the definition of employee, Mr. McCabe.
Well, let's look at it. It says any person who receives remuneration from an employee for the performance of any work, any work or service, while engaged in any employment under any appointment or contract.
Correct. And Rahoff, the 1960 Supreme Court case, says that the determination of an employment status in Florida is based on contract. Now, it doesn't have to be a written contract. You know that. We can establish a contract of employment through action, acquiescence.
Well, what was the implication? Let's just accept as a fact that there was no written contract, because I think we can all agree on that. What was the implication? They weren't going there to have fun. They weren't going there. It wasn't a party. It wasn't.
It's an interview.
It wasn't a vacation.
It's an interview.
They were paying him for it, though. They were paying him to learn how to. No,
Judge. Look, I'm getting paid by my clients a per diem right now. I've been here I've done 3 oral arguments in 2 days. They put me up in a hotel. They gave me mileage, and they're paying for my meals. That doesn't make me the employee of my clients. Okay. Now, my law firm. Back when we used to hire lawyers, which we don't seem to do anymore, but we used to invite lawyers to come from the University of Miami or Emory or whatever. We'd put them up for 2 days. We'd interview them, they'd meet all the partners, they'd go to lunch, they'd go to dinner, and at the end of that 2 days, they might get a job offer and they might not get a job offer.
But did they perform any work for you during those 2 days?
Well, we got writing samples from them and all that type of stuff, but look at this, Judge. Okay, this is a trucking company. Did he provide any trucking services?
Tell us what he was doing during the orient, just a general overview.
Well, he went through classes.
Classes to do what?
To talk about what the requirements are of the company should you become an employee.
So to learn the policies of the company.
Learn the policies of the company. He took a drug test. Now, Mr. McCabe says, well, he knew he didn't take drugs. Well, we didn't know he didn't take drugs. And he had to take a written exam. He had to, they did the background checks to make sure he had his DOT licensure. And Judge, look, I represent a lot of trucking companies. This is the way it's done universally in the over-the-road trucking industry.
Well, learning that is not in service of the employer?
He's not learning his own
all
benefit.
those rules and regulations.
Company
policies is not in service of the employer?
No, Judge, this is a 2-day interview process. At the end of the 2-day interview process, you either get a job or you do not. Some of them got, listen, what about the ones that went home, Judge?
We can call them that, but they said they paid him wages. I mean, who pays wages for somebody to go to an interview? I never got wages to go to an interview in my life. I mean, what is that all about?
Well, as Judge Thomas points out, it's a per diem. And
Did you pay wages to the lawyers that you were trying to recruit, who you interviewed?
No.
You paid them to come up to interview.
Right.
You paid for their hotels.
I think the only difference between
and if they got hired,
right.
Did you go back and pay them for the 2 days of
signing bonuses? We gave them signing bonuses when they said yes. So yes, we did.
That's not the same
No,
thing.
it is. Why is it any different,
What
Judge?
is this part of
Why is it any different than a signing bonus?
What does this part of the statute mean? Or apprenticeship, express or implied, oral or written?
I don't have a clue. I couldn't find a case on what apprenticeship means. But what I do know is Rahoff tells me that a contract of employment is not completed until the last act necessary to complete that contract has occurred, and the offeror is free to set the terms of what you have to do in order to complete that contract. And my client is the offeror. And they said, the piece of paper that he read you, that he held up, it said this is not an offer of employment.
Which means perhaps Mr. Jenks could not have filed a breach of contract action.
Right.
But doesn't mean he's not entitled to workers' comp.
I think it does mean he's not entitled to workers' comp because read Rahoff and all the cases that cite Rahoff. They talk about in the context of workers' comp, when does the employment begin? And usually the context of most of these disputes is whether the contract was formed in Florida or some other state, because we're trying to figure out if we're subject to Florida laws. That's the context that most often comes up. But what they say is either for the claimant or against the claimant is this contract was or it was not formed based on whether or not these terms were required in order to establish employment, and that the terms are set forth by the offeror. His subjective belief is meaningless. The claimant's subjective belief that he thought he was hired, he said, well, I didn't read the paperwork that says it wasn't an offer of employment. I assumed I was hired. But they are free to set the terms, and the DOT requires them to do certain things, and that's in the record from the employer representative. We are not allowed under DOT rules to hire people until we do A, B, or C. Not people in general, but over-the-road truckers, okay? So they said, we are asking these, I don't remember how many people it was, let's say it was 20 people, to come and spend 2 days at our facility. Some will become employees and some won't. Some didn't, some did. This guy did 5 hours after his accident, which occurred, by the way, while he was going to lunch in his wife's car. So unless you're going to say
I
that...
think going to lunch sort of at the insistence of the employer, right? Hey, I'm going to take y'all to lunch, and they said, we'll follow you in our car.
It's part of the orientation.
I mean, let me just ask you about that before you interject.
Sure.
So I understand your argument, and obviously Rahoff controls in terms of deciding whether a contract exists. But isn't it true that the employer told him, hey, I'm taking you to lunch? Now, maybe that's like you when you tell your aspiring recent law school grads, we're taking you to lunch. Certainly they're not going to say, no thanks, I'll go to Burger King, I don't want to join you for lunch. They probably won't get the offer. He's controlling him, right?
Yeah, and Judge, I didn't make a lot of, I didn't really focus in my brief at all about he was going to lunch in his wife's car. And the reason I didn't is that the judge didn't really find that that made any difference. The judge didn't, for example, find, it was raised in the pretrial. Okay, in the pretrial they said he was not an employee and the accident wasn't in course and scope, which seems to suggest it's a lunch break accident, right? And in the cross-examination of the claimant, the trial lawyer, the trial defense lawyer representing the carrier, said, isn't it true you were injured in your wife's car, and isn't it true you were injured on a lunch break on your way to a restaurant? But the judge didn't base his ruling at all on that fact. What the judge based his ruling on, remember, it was a bifurcated hearing. What the judge based his ruling on exclusively was the fact that he was not yet an employee. The contract of employment had not been consummated at the time of the accident. He had not yet received an offer and acceptance of employment. And the case they point out from Tennessee, Judge Clark, that you bring up or you asked about, the court in that case made an unambiguous ruling that the offer and acceptance happened before the orientation. So the contract had been formed before the orientation, whereas in this case we have a finding that's exactly the opposite, that the contract was not formed until at the end of orientation 5 hours after the accident.
Does an employment relationship have to be permanent under the, I mean, I'll grant you he was not a permanent employee, but what I'm having trouble with is, wasn't he an employee under the definition of the workers' compensation law under an implied contract for 2 or 3 days during that orientation? He was paid wages. They made an implied agreement with him. You come here, we will pay you wages. Your part of the deal is you'll attend these seminars, you'll learn how to drive trucks, you'll learn about the traffic code, you'll learn about the company policies, whatever it is we're going to ask you to do, you'll do that and we will pay you.
No, that wasn't the contract. They said we will pay you if we give you a job. And those
so he only got the money if he got the job?
Yes, Judge. Those that left the orientation, those that were sent home because they failed a drug test or
got no money.
Got zero.
What about those who completed the orientation but then subsequently didn't get hired?
They didn't get the $50 either. The uncontroverted, unchallengeable evidence is that only the people that got hired got the $50. Now, yes, they got it retroactive, and they coded it in a certain way on their payroll records. But let's say there were 20 people and 16 of them got the job. 16 of those people got the $50 a day and 4 didn't. And let me ask you this. Those people come in for their 2-day orientation.
If it's not wages, what is it? I mean, he's got to pay taxes on it like it's wages.
Well, I assume it's taxable income, and what they called it was a startup fund or a gratuity or something like that. But it looks to me like a signing bonus. I mean, if you look at it and you say, what is this? Okay, well, did the ones that get the job get the money? Yes. Did the ones that didn't get the job get the money? No. Sounds like a signing bonus. Not a very impressive signing bonus, but it's $50 a day. So, Judge, I don't think it turns on that at all. I think that actually works in our favor because those that didn't get the job didn't get the $50. Okay, and then it becomes exactly, Judge Clark, like my law firm interview example, because the people that come and interview at my law firm do get lunch and they get a hotel and I pay for their airfare, but they don't get paid. They don't get paid unless they take a job, and if they take a job, then they get a signing bonus. So to me, it's no different. And let me ask you this, Judge Padovano. What about those?
Well, we asked the questions here, but go ahead. I'll answer your question.
Okay. Well,
we'll just break some new ground here. I'll answer your question.
Let me just say it in the form of a declaratory statement then.
Okay. You know I'm just kidding.
I know you are. I know you are. And you almost threw me off, but not quite. What about the let's say it was 4 that got sent home, right? Do they then get to bring wage and hour claims because they didn't get paid $50? Do they get to make unemployment compensation claims because they had a job for 16 hours and now they don't have a job? No, because they weren't employees. And they weren't employees.
Well, you really don't know the answer to that. They may make a wage and hour claim. You can't predict you're confident now, but I don't think it's as effective, just to let you know from my perspective, as your law interview analogy, because you don't know, and we don't know better yet. I don't mean you don't know.
Yes.
I don't know. And whether or not they would have a valid wage and hour claim. I appreciate your argument that they wouldn't, because they were told this is a 2-day period and you don't get paid unless you get the job. But I would submit to you that I'm not sure there won't come a time when such a wage and hour claim may not be raised, it may not prove successful.
And Judge, I think.
May not even be a class action.
My confidence springs from the Rahoff case and the cases that are like Rahoff. Because Rahoff and the Supreme Court case, that Supreme Court case, tells us what you have to establish to have an employment contract. And Judge, it says right there in the definition of employee, it's got to be under any employment contract. And then you say express or implied, that's modifier of contract. You still have to have an employment contract. And no, it doesn't have to be written. But in this case, we actually have some written documentation which says, quote, this is not an offer of employment and should not be viewed as such, right at the top. Right at the top. And he signed it. He said, well, I didn't read it. So we think that the bottom line is that the employment contract was not formed until after the accident occurred, and therefore there is no workers' compensation coverage. And that's our...
But if he got paid the $50, if in fact he got the employment contract, and he did in fact get the employment contract, then was he not employed all along?
No, Judge, I don't think there's any legal support for that.
Why are you giving him the $50? He did get the $50.
Because he did. But Judge, think about Rahoff, okay, the Rahoff case, which it talked about. You have to do A, B, and C, and when you get to C, you now have an employment contract because that's the terms you have to complete. It doesn't go on to say, and now we find that there's a retroactive period of disemployment back to when you did the first thing. Because that's not the way it works.
That may be true as a general proposition, but your company did, or the company your carrier covers, did pay him retroactively during that time.
They did give him a $50 per day, whatever it was.
Well, it was wages. They said that in their paperwork.
Sure.
Wages.
Yeah, and like I said, I mean, a signing bonus is wages. Any cash payment that I give to an employee is considered to be wages.
But this was specifically wages for those 2 days.
Yes, ma'am. I concede that that's the case, that the agreement was, if you come to, I think it was Auburndale, for this 2-day period, you successfully complete everything you need to complete, and we offer you a job, and you accept it because he was free to go home, and he admitted that, then we will pay you $50 a day if all of those things occur. I just look at it, to me, as a matter of contract. It's a matter of contract, and I think that's my case. And if there are no further questions, I'll sit down.
Thank you.
Thank you.
Just briefly, the form that he signed says orientation pay, and it says effective, it's on page 44 of the record, effective March 8, 2006, all new drivers will receive $50 per day upon successful completion of orientation. This is for new first-time drivers qualified with Bynum Transport Inc. So, but again, he did successfully complete orientation. He was paid the wages. And this is not an interview. This is not where some guy just comes to the office and gets interviewed and then goes and we'll contact you. He was going through orientation, and immediately when it was completed, he's sent out on the road. So we submit that he was an employee while undergoing orientation. Thank you.
Thank you.